The room is very formal. It's very ornate. It's the nation's highest court. Anytime you walk in that room, you're struck by the enormity of their historic decisions. This is one of those decisions that law students will be learning about for decades. This isn't the typical lawsuit. The justices were very well prepared as expected. 8 of the 9 justices peppered the 3 sets of lawyers, and it was clear that they wanted to hear the merits of the case and that the Anti-Injunction Act was not going to bar the lawsuit. 2 circuit courts claimed that the Anti-Injunction Act barred the suit. 2 federal appellate courts. Yesterday was a big step in the process. One of the justices' former law clerks wrote the opinion in one of those 2 circuit courts. So it was a big issue. There was no difference among the ideologies. Everyone thought that we needed to get to the merits. The only justice who didn't speak is Justice Thomas. And as you know, Justice Thomas doesn't speak at these hearings. He was animated. He asked his clerk for some law books, etc., but he didn't ask any questions. I thought Justice Kennedy had a comment or 2 that was very interesting, since he's considered the swing vote. Justice Breyer made a comment that clearly would lean towards support of the overall act. And Justice Alito provided the only humor of the day, where he looked at the Solicitor General and said, so today you're telling me it's a penalty and not a tax, and tomorrow you're going to come in here and tell me it's a tax, which of course is exactly what happened. And I think the justices are saying, no, hold it, credibility is important. You can't have it both ways. Even if you knew which way they were going, the decision's wording is going to be very important in many of those instances. And keep in mind, we have 2 mandates in this suit. Not only the individual mandate, but the expansion of Medicaid. You have the issue also tomorrow afternoon regarding severability. So if you knew that they were going to strike the individual mandate or the expansion of Medicaid, which of course we don't know, but you then don't know the issue of severability, we've got to wait for the decision.